Thank you all for coming tonight. Thank you, Paul. I'm president of the New Mexico Lawyers Chapter of Federalist Society. And Federalist Society, for those who don't know, is a group of both conservative and libertarian legal scholars and lawyers founded on the principles that the state exists to preserve freedom, the separation of governmental powers is central to our Constitution, that it's emphatically the province and duty of the judiciary to say what the law is and not what it should be. As always, the Federalist Society takes no position on particular legal or public policy issues or political races, including judicial races. Our next event is going to be Wednesday, March 18th. It's going to be a lunch meeting. A lunch speaker will be Professor Brian Fitzpatrick of Vanderbilt Law School, and he will talk about a conservative case of class actions. That will be at Seasons Rotisserie Grill, and we will advertise that. Well, our speaker tonight is Josh Blackman, Associate Professor of Law at South Texas College of Law in Houston, where he specializes in teaching constitutional law. He's an amazingly productive scholar. Countless articles, op-eds, amicus curiae briefs, and blog posts to his credit on all manner of legal issues. If you go and look at his CV online, you will get hired just from reading it. These works include the two books on the Obamacare litigation. The Obamacare litigation continues. It's a never-ending story. The one is called Unprecedented, the Constitutional Challenge to Obamacare, published in 2013, and Unraveled, Obamacare, Religious Liberty and Executive Power, published in 2016. And there's a forthcoming third volume coming in 2022. It's sort of like a Lord of the Rings trilogy.
It's like the movie Groundhog Day, but instead of Bill Murray, we have John Roberts. Just keeps repeating over and over again.
Professor Blackman obtained his Bachelor of Science degree from Penn State and his law degree from George Mason Law School, now known as Antonin Scalia Law School. The most recent book and sort of inspiration for his talk today is co-authored with Georgetown Law Professor Randy Barnett, is an Introduction to Constitutional Law, 100 Supreme Court cases everyone should know. Now I'll turn it over to Professor Blackman. Thanks for being with us.
Thank you so much. And you've been a wonderful host. This is my first time in New Mexico. Never been here before. Thank you to Emil and the Rio Grande Foundation, the students at the chapter from the law school. They host me for lunch. I've been in this exact same room all day, and I'm very happy to be here. You have a show tonight. My goal is to cover 100 Supreme Court cases in 1 hour. You ready? I can do it. All right, get ready. And I know a lot of you are not attorneys. Don't worry, this will make sense, I promise. We've divided the Supreme Court's cases into 15 parts, mostly chronological, but we do jump around a little bit. And my goal is to teach you what are the important cases people should know from the Supreme Court, why are they important, and how do they impact where we are today. And we have to start at the very beginning with what we call foundational cases at the basis of our Constitution. And we go all the way back to 1793 with a case called Chisholm versus Georgia. You all don't like your government. I can tell that from your introduction. You're unhappy with your government. And what do you do if your government does something wrong to you? You vote. But can you sue your state? Can you take your state of New Mexico to court and say, nope, you're breaking the law? The general answer is no. And that ruling stretches all the way back to the 1790s. The Supreme Court initially said that, yes, you can sue your own state. Wouldn't that be nice? But then the Supreme Court was overruled by the people. The 11th Amendment to the Constitution was added, which says you cannot sue a state, number one. Number two, this is a case which probably most of you have heard of, Marbury versus Madison. This case established the principle that our Supreme Court can declare laws unconstitutional. But the Supreme Court didn't make up what we call today judicial review. It was actually a very simple principle. If Congress enacts a law, and that law is in conflict with the Constitution, a higher power, the higher power controls, and the courts give weight to the Constitution. And that's the basis of Marbury. And Marbury is written by a very famous judge, Chief Justice John Marshall, who was a great Chief Justice for almost 30 years. Number 3 is also a case involving Chief Justice Marshall, McCulloch versus Maryland. This was a question about whether Congress could create a federal bank. Our Congress has limited powers. You wouldn't know it, but they do. Congress has only those powers that are listed or enumerated in the Constitution. And if a power is not listed, Congress lacks that authority. Is there anything in the Constitution that says Congress can make a bank? No. But the court said that Congress can do it anyway. Why? Because Congress has other powers, which are not expressly listed, but are suggested by the text of the Constitution. This was the case that started the process to where we are today, where the federal government can exercise powers that are not written down, but have been implied from other provisions of the Constitution. Number 4, Gibbons against Ogden, 1824. Let's say you have a steamboat going from New Jersey to New York. And let's say New York passes a law banning steamboat traffic. Is that law constitutional? The court holds no. The power to regulate commerce between the states, the movement of ships, belongs to the federal government, not the states. And this is an important doctrine which limits protectionism, right? New York wanted to limit business from out of state, protect its local businesses. This decision said, no, Congress is the only branch that can restrict interstate commerce. Okay? My thing is not working. All right, it's okay. Number 5, Barron against Baltimore. We all know what the Bill of Rights is, right? The first 10 amendments that talk about free speech and the right to bear arms, and the government can't search your stuff without permission, right? Now, who does the Bill of Rights limit? Does it limit the power of the federal government? Or does it limit the power of the state governments? Barron held at a very early year, 1833, that our Bill of Rights only limits federal power, not state power. So if the state government wants to take your property without paying you for it, they can do it. But let me tell you a good story. The ruling in 1833 is not the law today. After the Civil War, we enacted the 14th Amendment. And the 14th Amendment said that the same rights that are protected for the federal government are also protected by the state governments. So today, if the government takes your property, they got to pay you for it, which is a good thing. You with me so far? Basis. All right. We move to part 2, what we call enumerated powers. Okay? Enumerated powers is the concept that Congress only has those powers that are written down. I think it's a good idea and it's just a general matter. The first case is from 1842, Prigg v. Pennsylvania. This is an awful case. Congress enacted a law called the Fugitive Slave Act. What was this law? If a slave managed to run away from a slave state to a free state, this law ensured that the slave could be captured and brought back down south. Was there any provision in the Constitution that gave Congress this power? No, there was not. But the Supreme Court said, aha, Congress has other powers beyond those written down. You're seeing the projection, right? And this is a case where you don't like federal power, because federal power basically gave slave catchers a blank check. The next case, no one's ever heard of, but significant. 1869, United States against DeWitt. Congress passed a law that banned the sale of oil, petroleum. in local markets. Wait a minute, Josh. I thought Congress could only ban the sale of stuff in interstate marketplaces. Can they ban local sales? The Supreme Court said no. That's for the states to regulate local sales and not Congress. Number 8. Hepburn against Griswold. All right, pop quiz, everyone. Take out a piece of currency in your wallet. I'll teach you something new, right? Take out any piece of currency. I got a 20 right here. And you'll notice on the front, it says in little bitty letters, this note is legal tender for all debts, public and private. Did anyone ever notice that before? Does anyone know what it means? Legal tender is a concept that means you are required to accept this. If I go to a business and I hand them this piece of paper, which is basically worthless, right? They are obligated to accept it. Now you can imagine this was a very unpopular concept for many years. Why? Paper money was worthless. People wanted gold. They wanted things of actual value. During the Civil War, Congress actually created the first bout of paper money, which was legal tender. It had to be accepted. This was what the first greenback looked like. It was called a greenback. It was basically a green piece of paper. The constitutionality of this law was challenged. People said, I don't want this paper money, give me gold. The Supreme Court said in 1870, paper money, unconstitutional. Congress does not have the power to make you accept paper money. Now I see some confused looks in your faces. Wait a minute, Josh, you mean I don't have to take paper money, I can take gold? This decision was short-lived. It lasted for 1 year. This was 1870. The next year, 1871, 2 new members were appointed to the Supreme Court. These were pro-paper money justices, and they reversed Hepburn. They overruled it, and they held that legal tender is constitutional. So you see in the span of 1 year, when you appoint 2 new justices, you get a completely different Supreme Court decision. And that is why all of you must accept the stupid paper money that we have today. Okay? Let's jump forward a few years to the 1890s. United States against E.C. Knight. This case involved a sugar monopoly. You had the American Sugar Refining Company purchase one of its competitors. Now today we know what antitrust law is, that you can't have monopolies. But that was a fairly novel concept in the 1890s. And the Supreme Court actually held that this enforcement was unconstitutional, that Congress could not prohibit the local manufacture of sugar. They could ban perhaps shipping sugar across state lines, but they couldn't prohibit the local manufacture of sugar. So here you have a decision that narrows federal power. Number 11, Champion v. Ames, 1903. This case involved lottery tickets. Could Congress ban the shipment of lottery tickets across state lines? The court says yes. But then we go to 1918, during the middle of World War I. A case called Hammer versus Dagenhart. Here, Congress tried to prohibit child labor. And they said any good manufactured with child labor cannot be shipped across state lines. The Supreme Court said that that law was unconstitutional, that labor conditions were local, and the states were obligated to regulate labor conditions, not the federal government. All right. We jump ahead to the 1930s in a period called the New Deal during the Roosevelt Administration. I'm sure many of you are familiar with this period. There was a lot of change going on in our country in a very short time. In 1935, the court considered a case called Schechter Poultry. It involved, as the name suggests, a butcher shop. The Roosevelt administration created a series of codes, fair labor codes, where butchers had to meet different criteria, different conditions. And the Supreme Court held that a butcher shop is not engaging in commerce among the several states. That a butcher who slaughters a chicken in Brooklyn is not shipping that chicken to other jurisdictions. Therefore, Congress and the federal government had no power over a local butcher shop. This was the last decision I'm going to mention for a very long time where the government lost. After 1937, the government wins, and wins. And federal power gets bigger, bigger, bigger. My arms aren't big enough. It gets really big. We get to 1937. National Labor Relations Board, NLRB, versus Jones and Laughlin Steel. This was a test to the constitutionality of the National Labor Board. We heard earlier about unions. This was the big case, right? If this case came out the other way, most of federal labor law would be void. You couldn't have federal protection for unions. But here the court upheld the rights of unions to organize and the rights of the government to punish companies that bust unions. The Jones and Laughlin Steel Company said, we don't want to be bound by these labor laws, screw that. And the court said these labor laws are valid. This was the beginning of the federal growth in federal labor law. Another case, United States versus Darby, 1941, held that Congress can set a wage for workers in the lumber industry. Before that, the states were setting the wages, but now Congress was setting a national wage for workers in certain industries. But the next case was what blew everything open. Wickard against Filburn, 1942. Let's say you're a farmer and you grow some wheat on your farm and you eat that wheat with your family and maybe you give some of that wheat to your livestock. Are you engaging in interstate commerce? Of course not. It's locally grown wheat. It's locally consumed. It never leaves your farm. But this case, Wickard changed direction. It said even purely local activity, growing wheat, is regulable by Congress. Why? Because your decision to grow local wheat might affect commerce in other states. And in order to stop this unfair competition, Congress can shut down your farm and tell you, we're going to penalize you if you grow down too much wheat. And with this decision, almost every activity imaginable is now within the scope of federal power. We jump ahead to the 1960s in the Civil Rights era. The first case we want to talk about is Heart of Atlanta Motel. The Civil Rights Act of '64 prohibited segregation in places of public accommodation. A hotel that was segregated in Atlanta said, no, we want to keep our segregation policies. This is beyond federal power. The court disagreed. The court said this hotel attracts customers from out of state, and those people driving down the highway are interstate commerce. Therefore, the hotel itself could be regulated. What about a barbecue restaurant? Ollie's Barbecue. It was in Birmingham, Alabama. It did not cater to out-of-state customers. It had no out-of-state customers. Could Congress regulate this local barbecue joint? Yes. Why? Because the food they used came from out of state. The utensils they used came from out of state. The pots and pans they used in the restaurant came from out of state. You see where I'm going with this, right? Virtually anything you do that touches interstate commerce puts you within the clause of the federal government indefinitely. We actually call it the Commerce Clause, right? Because they get your claws on you. That's what I did there, right? In fact, I have proof. I found a matchbook from the Heart of Atlanta Barbecue that was manufactured in Atlanta, right? So they actually imported from Georgia to Alabama matchbooks. So I have proof that they were engaging in interstate commerce. I have a lot of collections and knickknacks. Let's jump ahead 20 years to the 1980s. South Dakota v. Dole. What is the drinking age nationwide? It's 21, right? It was not always 21. Those you may remember in the 80s, it was varied. Some states had 21, some states had 18, some 19, some 20. How could it be that all these states reached the same exact drinking age? It wasn't by chance, right? It wasn't by chance. Congress told the states, hey, we're going to give you some money for federal highways, right? And if you want this money, jack up your drinking age to 21. And if you don't raise your drinking age to 21, we'll take the money away. So how many states actually went along with this? Just about all of them, except for South Dakota. South Dakota argued that you can't make us change our drinking age, and you can't dangle this, this money in our face. It's coercive. The Supreme Court disagreed. And the Supreme Court said, yes, Congress can do it because it's not coercive. If they don't raise their drinking age, just turn down the money. What state turns down federal money? None of them, which means that states have basically surrendered some of their autonomy to govern their citizens in order to get this lovely dangling money. Let's jump ahead to 1995, U.S. against Lopez. This case involved the Gun-Free School Zone Act, right? Congress passed a law that made it a crime to possess a gun in a school zone. Now, Congress can certainly regulate shipment of guns across state lines and maybe regulate a gun that traveled in different states, but can they possess simple possession? Can Congress ban simple possession? The court held no. The court held no. Merely possessing a gun in a school is not an economic activity, and Congress cannot regulate it. Therefore, the Gun-Free School Zone Act was unconstitutional. This case made people freak out. Say, oh my God, for the first time since the 1930s, the Supreme Court found a federal law unconstitutional on Commerce Clause grounds. Oh my God, the world's going to end. Not really. This was actually pretty mild. A couple years later, we come to 2000 with a case called United States against Morrison. And this law tried to basically make it a crime to engage in domestic violence. Now, we all know domestic violence can be punished by the state. No problem with that. But here, Congress wants to let the victims of domestic violence go to court and sue their perpetrator, right? Isn't domestic violence, family matters, and things like that a matter for the state governments? The Supreme Court said yes, that domestic violence was not an economic activity, and therefore Congress could not regulate it. Okay, so another federal law was found to be unconstitutional. It's number 22. The next case switches direction. 2005 Gonzalez versus Raich. This case involved medicinal marijuana. What if you grow marijuana in your backyard? The plant never travels to another state, it's never sold, you consume it in your home. Can Congress regulate locally grown marijuana? The court said yes. Why? Congress has an interest in banning the shipment of pot from California to Nevada. Therefore, to limit the amount that can be shipped across state lines, they can ban locally grown marijuana. This law was essential to the broad regulatory scheme to regulate narcotics nationwide. This case put the brakes on any sort of limitation on federal power. And the next case, number 23, breaks my heart every time I see it. It's the first Obamacare decision from 2012. Can Congress make you buy health insurance? John Roberts or Bill Murray tells us no. But can Congress tax you for going uninsured? Well, sure they can. And thus Obamacare was saved, but maybe not for long. Just this morning, the Supreme Court decided to hear a second case about Obamacare. Actually, really a third, depending on how you count. I've written 2 books on Obamacare. This is my first one. It was called Unprecedented from 2013. I have another one from 2016 called Unraveled. And 2022, give or take, I have another book called Undone. So my entire life is basically writing Obamacare books and eventually speaking to you all about it. Okay? All right, we are done with implied powers. Next, we're going to a topic that's probably dear to your hearts, which is federalism. Federalism is a notion that the states have certain powers, and those powers put limitations on the powers of Congress. And the first case from 1992 involves radioactive waste. Sounds dangerous, but it's actually not that bad. No one wants to deal with radioactive waste. Go look at Nevada, right? The Yucca Mountain thing that's been going on forever, right? What do you do with all this waste? This issue just doesn't go away. So Congress passed a law that told the states, hey, if you have any radioactive waste in your state and you don't take care of it, guess what? You're on the hook. You have to pay for it. And New York said, no, 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 no. You can't make us take title, to take ownership of this radioactive waste, right? You can't tell New York what to do. Imagine that, right? Nothing ever changes. I'm from New York, by the way, but I've been here in a very long time. I'm happy to live in Texas. The Supreme Court in New York against the United States agreed. The Supreme Court said that Congress cannot issue orders to the states. Congress cannot commandeer the states to take ownership of the radioactive waste. This is known as the anti-commandeering principle. Fast forward to 1997. We have the Brady handgun bill. Joe Biden is always in the news touting this law when the core provisions were declared unconstitutional. Congress passed a law that mandated certain background checks. Today we have computers and the NICS, the Instant Background Check Database, which lets you quickly buy a federal firearm. That did not exist in the 1990s. So Congress had an idea. It said, okay, until we develop this background check database, let's order local sheriffs to run background checks for people. Who thought that was a good idea? These two sheriffs, right? This was from sheriff from Arizona. This was a sheriff from Montana. Do you think these guys want to run background checks for their citizens who want to buy guns? Hell no, absolutely not. And they said, you cannot force us to engage in this federal process. And the Supreme Court agreed, right? They agreed. And they held that this was commandeering. All right. Let's jump ahead to a slightly different topic. I mentioned earlier that generally you can't sue a state. Hans v. Louisiana reaffirmed that you can't sue another state and you can't sue your own state. What about Congress? What if Congress says, you know what? We want to let certain people sue the state of Florida, right? We think it's a good idea. And the Supreme Court put limits on when a state can be sued. This was Seminole Tribe of Florida versus Florida, 1996. And in the next case, Boerne V Flores, the court put more limits. They said, generally, the states cannot be sued, and they sort of pivoted to a different direction in 2003, where they said, well, there are some cases where a state can be sued. This is a very volatile area of the law that I think can very likely change in the future. So don't worry too much about it now. Part 4. So far, we've talked only about congressional power, legislative branch. Let's move on to the next branch, the executive power, the president. The very first case from 1861 involves President Lincoln. You may have heard of something called the writ of habeas corpus, right? It's literally for Latin. In Latin, it means here's the body, right? Habeas corpus. Under this old doctrine, if you're ever detained by the police or detained by the government, you have the right to appear before a judge and have the judge say, yes, this detention is legal. But during the Civil War, President Lincoln suspended the writ of habeas corpus. He told his commanders, you can lock people up and you don't have to bring them before a court. In Maryland, the Union Army locked up John Merriman. They would not give him a hearing. And somehow Merriman's friends went to the Chief Justice, Roger Taney, and said, Justice Taney, help us, our guy's being locked up. And Justice Taney ruled that President Lincoln cannot suspend the writ of habeas corpus. Was Merriman released? Nope. So Lincoln didn't actually ignore the ruling. It's often said he did. That's not what happened. But at the time, the general basically said, I'm following orders. And the Chief Justice didn't actually order his release. All the Chief Justice said was, this is illegal. But here we have an early case where the executive and the judicial clash. Fast forward to World War II. You've probably heard of this case. Korematsu against the United States, 1944. During World War II, President Roosevelt had a policy known as Japanese internment, and it was exactly what it described. People of Japanese descent, both citizens and non-citizens, were required to be excluded from their homes and relocated to these various camps throughout the West. I'm pretty sure there were some in New Mexico, if memory serves. The Supreme Court ruled that the exclusion of these people from their homes was constitutional. The court upheld the exclusion policy. The court also held in the same day you can't lock them up, right? In other words, you could exclude them from their homes, but Roosevelt couldn't put them in camps. Huh? Here's some background. By the time the Supreme Court decided Korematsu, Roosevelt had already shut down the policy. By the time the court ruled, FDR had already announced he would no longer do this. And there's some evidence they knew. The justices knew this was coming. So the decision amounted to nothing but to giving the president this power. Let's go ahead about a decade to the Korean War in 1952. When I say the Korean War to my students, they don't know what the hell that is. Do you guys know what the Korean War is? See? Smart students right there. The Korean War was happening in the 1950s. But there was civil unrest at home. A union, the Steelworkers Union, threatened to go on strike. Yeah, nothing changes, right? The steelworkers threatened to go on strike. What did President Truman do? He ordered his government to take control of the steel mills, to take ownership of the steel mills. The Supreme Court said, no, you can't do that. The president cannot seize private property. It's not Venezuela, right? You can't do that. And indeed, Truman shut down his program and put it back in the hands of the private ownership. The union went on strike, lasted a couple months, eventually they worked it out. Nothing changes. Part 5, what are called the separation of powers, the idea that the legislature, the executive, and the judicial are and should be separate. The first case came from the Reagan administration. 1988, Morrison against Olson. You all remember Ken Starr, the independent counsel, right? What the hell is an independent counsel? Where does an independent counsel fit in our 3 branches of government? He has an answer to the president. He has an answer to Congress. He kind of answers to the courts. And in this case, 1988, the court held that the independent counsel statute was constitutional. Number 34 from 2014, Nlrb versus Noel Canning. This was a case where the Congress was in recess for 3 days. The Senate took a 3-day break. And during that 3-day break, President Obama made appointments to the NLRB. A 3-day break. Can't do that. The Supreme Court said 9-0 that a 3-day break is not long enough to make a recess appointment. You need a bigger period of time. Okay? We now move on to a period that was long ago. Slavery and Reconstruction. The first case I want to mention is from 1857. You probably know this case. Dred Scott against Sanford. This case upheld the constitutionality of slavery. This case said that slavery was sanctioned by the Constitution. Indeed, the court basically said that slaves, people of African descent, could never be free. The Supreme Court never overruled Slaughterhouse. What overruled Slaughterhouse was the 13th, 14th, and 15th Amendments to the United States Constitution. And it shows that we, the people, were able to nullify this awful decision. Number 36, the Slaughterhouse cases. This was the first case decided what the 14th Amendment meant. The facts were kind of obscure. New Orleans created a monopoly for butcher shops, that all animals have to be slaughtered in a single place. A bunch of butchers said that that was a violation of their economic liberty, their right to contract. The Supreme Court said, nope, that right is not protected by the 14th Amendment. The next case, Bradwell v. Illinois, 1873, involved a woman who wanted to be an attorney. And she argued that she had an economic right, an economic liberty, to become and work in the profession of her choice. What did the Supreme Court say? Nope, 14th Amendment does not protect that either. Next case, 38. This is a gruesome case, United States against Cruikshank. In Colfax, Louisiana, there was a lynching where a group of African-American militiamen were burned alive in a church by a white lynch mob. The lynch mob was prosecuted for depriving the freedmen of their constitutional rights, the right to bear arms and the right to peacefully assemble. Does the 14th Amendment protect the right to peacefully assemble and bear arms? Nope, 14th Amendment protects nothing. So these decisions basically said the 14th Amendment didn't change that much. 39, Strauder against West Virginia. This was one of the rare bright spots in this line of cases. West Virginia had a law that said that all juries must be segregated, that black men were not allowed on juries, no women at all. And the Supreme Court said that this law was unconstitutional. You cannot deny African Americans the right to sit on a jury. Number 40, civil rights cases. Here, Congress tried to enact a law that ensured racial equality in place of public accommodation, that you could not exclude people on the basis of their race from theaters, from hotels and restaurants. What did the Supreme Court say? Nope, can't do that either. Seeing a pattern. The Supreme Court read the 14th Amendment so narrowly, so strictly, so as to have almost no meaning. Number 41, Yickwo against Hopkins, 1886. This was also another rare bright spot, but a complicated case. At the time in the city of San Francisco, almost all the laundromats were run by Chinese people. San Francisco had a law that said, if you want a license for a laundry business, you have to apply for one. All the white people got their licenses, all the Asian people did not get their licenses. And the Supreme Court said this was unconstitutional. 42, a case you've probably heard of, Plessy versus Ferguson. Here, the state of Louisiana had a segregated train law. You had to have a white car and a black car. And the Supreme Court said that's fine, under the doctrine known as separate but equal. Okay, we move on to the Due Process Clause. The 14th Amendment says that Congress cannot deprive you of life, liberty, or property without due process of law. What is liberty? In a series of early cases, the court said that liberty refers to economic liberty, the right to contract, the right to pursue the vocation of your choice. The most famous case from 1905 is Laughlin. Here in New York limited how many hours bakers could work per week. The Supreme Court said that they cannot do that, that the right of a baker to work was his own choice. In 1944, the state of Oregon limited how many hours women could work. But that's okay because women are fragile and delicate and need to be protected. So you're seeing already a bit of a double standard for men and women. 1945, Buchanan versus Worley. The city of Louisville, Kentucky banned interracial housing, that a white person cannot sell his house to a black person. Court says unconstitutional. Why? Because I have the liberty of contract to sell my property to whomever I want. 46, Atkins v. Children's Hospital. Here, the District of Columbia made a minimum wage for women alone, only women. And the court said that law is unconstitutional. Women should be allowed to bargain for whatever wage they can get. In other words, a constitutional right to starve. You can read the caption. Okay? 47, Meyer against Nebraska. This case involved raising your children. Nebraska passed a law that made it a crime to teach your kids a foreign language. This was a bit of xenophobia, another way to describe it. You had Meyer, who was a teacher of German Bible stories. He was a Lutheran teacher. And he taught Bible stories in German. He was arrested for doing so. And the court held that that cannot be done, that parents have the right to direct the upbringing of their children. Next case gets even worse, 48. Involves the nuns, Pierce v. Society of Sisters. The state of Oregon passed a law that made it a crime to send your kids to a private school. It was actually a crime to send your kids to a religious school of any sort. You had to send to public school. The Supreme Court said, no, you can't do that. That parents can direct the upbringing of their children, and that's a liberty protected by the 14th Amendment. Next case is a gruesome one. It involves eugenics. The state of Virginia passed a law that allowed for the involuntary sterilization of so-called imbeciles. Here, the state sought to sterilize Carrie Buck. They thought she was an imbecile. She wasn't. She was literate and graduated high school. Her only sin, if you can call it that, was getting pregnant out of marriage. But it's actually much worse than that. She was raped, and that's how she got married. That's how she got pregnant. But the state deemed her promiscuous, and they deemed her mother promiscuous, and they deemed her child an imbecile. And the court said 3 generations of imbeciles are enough. And the Supreme Court said that's fine. You can sterilize, carry buck, no problem. This case is actually still good law. Let's go back to economic cases. This case seems boring, but it's important. O'Gorman versus Hartford Fire. The state of New Jersey limited the commissions that are available on the sale of insurance policies. And the Supreme Court said that that's fine. You can do that. 51, Nebbia. Here, the state limited the price of bread. You have a minimum price of bread. Leo Nebbia was a grocer in upstate New York, and he had an idea as, aha, if you buy some bread, I'll give you milk for free. So you keep the price of bread nice and high, but I'll give you some free milk. He was arrested and charged with violating the law. And the Supreme Court said that was fine, that the state has an interest in protecting milk prices, really to protect the dairy farmers. That's the purpose of these laws. It wasn't to protect people. People had to pay more for milk as a result. Okay. 52, West Coast Hotel. Here's that year again, 1937. A lot of stuff changed in 37 after FDR was reelected. And the Supreme Court upheld a minimum wage law from the state of Washington. And once this law was upheld, the Supreme Court said any economic regulation works. This is why my good friends with the Rio Grande Foundation are beating themselves into a wall, because the courts have no interest in protecting economic freedom. They said we are not in this business. 53, U.S. v. Caroline Products, another important case. This case banned the sale of condensed milk. Huh? The dairy farmers did not like condensed milk because it's competition. You keep it in a can and it doesn't require refrigeration. So of course they got Congress to ban the sale of filled milk. And you had the owner of this company challenge it. The court said, no, no, no. The shipment of filled milk across state lines is interstate commerce. It's valid. What about Lee Optical? You ever hear of Lee Optical? It's actually in the Midwest. This is like a lens crafter business where you can go to a store, you take your glasses, they make a copy of it for you, and then they give you the copy, right? No eye doctors involved. Oklahoma hated this law. Why? They put the eye doctors out of business. So Oklahoma said a law that said to make lenses, you need a doctor. Even if the doctor didn't do anything, he had to just be on the property. And the Supreme Court said, that's fine, right? Even if this law makes no sense at all, there's no reason to have a doctor to manufacture glass, we're not going to question whether the law makes sense. If there's some possible rational basis for the law, that's good enough for us. Okay? Sorry, Part 8, racial discrimination. The first case from 54, is Brown v. Board of Education. You've probably heard of this case. This case involves public education, and the Supreme Court said that separate is not equal, and you cannot have segregated public schools. 56, Bowling versus Sharp, was another case from the District of Columbia, which held likewise that Congress cannot ban integration in federally owned public schools. How'd that work out? Not so good. In 1958, we had Cooper against Aaron. This case was part of the massive resistance where states throughout the country resisted integration. And in a famous scene from Little Rock, Arkansas, President Eisenhower sent in the 101st Airborne to escort black students to public school. And the Supreme Court said, integrate now! And what did they do? They did not. In fact, most school districts shut down rather than integrate. There are entire parts of the country that had no public schools at all for years to resist integration. 1967, Loving versus Virginia. Excuse me. This case involves a ban on interracial marriage. And the Supreme Court held you can't do that. That a ban on interracial marriage is unconstitutional. Okay. 59, Regents of the University of California versus Bakke. This case involves affirmative action. UC, it had what was called a quota, where a certain number of seats were set aside for minority applicants. The court said you cannot have a quota. And in 2003, you had Gratz and Bollinger. This is from the University of Michigan. The University of Michigan said that if you are a certain race, we'll basically add points to your application, right? Being black had more value than having a perfect 1600 SAT. The court said you can't do that. It's like a quota. But in 61, Grutter, the court said, well, you can have affirmative action in other ways, right? If race is one of many factors considered, Fisher versus Texas, and a follow-up case from 2016. Once again in 2016, the Supreme Court reaffirmed affirmative action. But at this point, Justice Scalia had passed, and the court was shorthanded. I think of all the cases in my litany, this one's on the chopping block. I don't think this one stands. If it's decided again, it goes the other way. Part 9, sex discrimination. The first case is called Frontier against Richardson, 1973. In the 1970s, there were not many female officers in the Air Force. In fact, they simply assumed that all the officers had wives instead of husbands. So if you were the husband of an Air Force officer, you were denied certain benefits. The court said you can't do that. Whatever benefits military wives get, military husbands have to get as well. Craig v. Boren, 1976. This case involved beer. Oklahoma said that if you were a guy, you can buy beer at 21, but if you're a girl, you can buy beer at 19 because girls are more responsible. True or not, I'll let you guys decide. Oh God, I'm not going there. Supreme Court said you can't do that. Unconstitutional gender discrimination. So what's the result? Can guys buy beer at 19? No, you level up. Girls have to wait till they're 21. So, everyone gets screwed when these cases go the way they do. 1996, United States against Virginia. Virginia operated the Virginia Military Institute. It was an all-male sex academy. An all-male military, that sounds really bad, an all-male military academy. And the court said that was unconstitutional. You have to admit girls on equal footing. Okay. 1985, Cleburne versus Cleburne Living Center. This case involves mental disability, which is kind of a weird fit. You had a group for mentally handicapped individuals that want to open a home, and the state denied their permit. And the court said that, no, you can't do this. You're discriminating against them because of their mental skills. All right. 1996, Romer against Evans. This case involves the first hint of gay rights. Colorado passed a law that made it harder for local cities to protect gay rights. The Supreme Court said you can't do that. You can't single out gays and lesbians for this disfavored treatment. At the time, gay marriage was not even a figment of the imagination. At the time, you could actually ban sodomy. But here the court, and really Justice Kennedy, was hinting that gay rights may creep into the constitutional discourse. Part 10, what's called substantive due process. The notion that the 14th Amendment protects rights like abortion. The first case I want to mention is Griswold v. Connecticut, 1965. This case considered whether the 14th Amendment protects a right to contraception, birth control. They said yes, it does. And Connecticut could not ban people from accessing birth control. But the next case needs no introduction, 1973, Roe versus Wade. Does the 14th Amendment protect the right to abortion? The court holds yes. During the first trimester, virtually no restrictions are allowed. During the second trimester, some restrictions are allowed. And during the third trimester, a lot of restrictions are allowed. They made this framework. Where'd they get this from? They made it up. This trimester framework wasn't a statute. The court developed it on its own through the sort of reasoning of judicial decision making. Is Roe good law today? Not exactly. In 1992, the court decided Planned Parenthood versus Casey. Planned Parenthood versus Casey. Pennsylvania passed certain abortion laws, and the court said, well, we don't agree with Roe. This trimester framework, we're going to get rid of it, right? Instead of drawing a line in the first, second, third trimester, we say viability. After viability, you can enact lots of restrictions, but before viability, you can't. But of course, when is viable, right? What's the point of viability? That's going to depend on technology, which will fluctuate year after year. So those who say, save Roe, Roe is good law, it's actually not. Casey is our governing standard. And to be more precise, the next case from 2016, this is our current law. Holman's Health versus Hellerstedt was a recent case from Texas where the court declared unconstitutional many abortion laws. If I had to pick a second case, it might be in the chopping block. I think it might be this one. I'm not sure this one lives for a few more trimesters. I think the court may kill it this semester, in fact. We got maybe 3 months to go. But there's a case being argued, I think on Tuesday or Wednesday of this week, where they're actually looking to revisit Holman's Healthy Hellerstedt. 2003, Lawrence against Texas. This case involves a right to homosexual right, almost there, a right to homosexual sodomy. That is, does the 14th Amendment protect the right of gay men to have sex? Court says yes. A decade later, in 2013, you have Windsor. Windsor considered the Defense of Marriage Act. This law basically told states who are not obligated to recognize out-of-state marriages that are same-sex, and the federal government will not recognize same-sex marriages. The court declares this law unconstitutional. It violates rights of dignity and autonomy, whatever those things are. Then we get to 75, the crescendo. In 2015, Obergefell v. Hodges. This case ruled that the right to same-sex marriage is protected by the Constitution, and nationwide, all states must acquiesce, must give in. And to be frank, since Obergefell, there's not been much muttering. I think people more or less accepted this. Not the same for abortion. I think there's still a fairly rigorous opposition, but for one reason or another, people have more or less fallen into line here with Obergefell almost 6 years ago. All right, now we get some fun stuff. Freedom of speech, Part 11. The first case, Schenck for the United States, involved World War I. Can you criticize the government? Can you criticize the war effort? Can you criticize the draft? Of course you can. Not in the 1920s. In fact, in a case called Schenck, 1919, Debs, 1919, Abrams, 1919, these three cases decided, one after the other, held that Congress can throw you in jail for criticizing the war effort, for criticizing the draft. These cases are not good law anymore. In Gitlow v. Gitlow v. New York, 1925, the court began to move away from this position, suggested the First Amendment limits the power to punish speech. And number 80, Stromberg, said that California is bound by the First Amendment. California banned flying a red flag. This was like basically a Bernie symbol, right? It was a socialist symbol, and the court said that you can't ban flying a red flag. 1968, O'Brien, draft card burning. Remember this, right? Can you arrest a person for burning a draft card? The court says yes, because the draft card is an important piece of information needed to monitor the draft. 1989, Texas against Johnson. Can you criminalize flag burning? No. Burning a flag is protected speech, the court tells us. RAV versus St. Paul. Can you criminalize cross burning? Ooh. At least not here, the court says. In other contexts where you want to burn a cross with the wrong intent, maybe they can criminalize it. Let's do campaign finance. We're talking about campaign finance earlier today with a podcast, which you should all subscribe to. Buckley versus Vallejo. Remember James Buckley? He's still alive, by the way. He was a federal judge. He's like in his 90s. He's a remarkable human being. What a life he's lived. Buckley v. Vallejo said that campaign finance laws are restricted by the First Amendment. So Congress can ban contributions to the candidate, but Congress can't ban expenditures to support issues. This is why you see, I am so-and-so, I support this message, right? Depending how the money's spent, you can escape these limitations. In 2003, Mcconnell v. FEC, this was the McCain-Feingold campaign bill. And the court upheld many of these restrictions, but about 7 years later, the court reversed that case in part with Citizens United. The court said that if you want to spend money, make a movie critical of Hillary Clinton, yes, you can. Yes, you can do that, even before an election. All right, next. We're actually right on pace for an hour. I got 7 minutes left. New York Times against Sullivan, 1964. You had an ad in the New York Times that criticized some members of the Montgomery, Alabama Police Department. The police department sued the New York Times for libel. The court said, no, you can't do that. When you are a public official, it's going to be very hard to recover for libel actions. Oh, this case. 2011, Snyder against Phelps. You know about the Westboro Baptists? These are awful human beings. They protest at military funerals, and they hold up the most awful signs. This is actually one of the better signs I could put on display for you all. Is their speech protected by the First Amendment? Yeah, it is. U.S. versus Stevens, 2010. This case is gross. Who here knows what a crush film is? You're all decent people. Oh, God, one of you raise your hand. This is a form of pornography where women step on little animals with high heels. Anyway, is filming that stuff protected speech? The court holds, yes it is, as gross as it is. You can punish the person for stomping the kitties, but you can't punish the recording of it. Brown versus EMA, 2011. California put limits on violent video games, that kids cannot buy these violent video games. The court said that that law was unconstitutional, that parents should be involved, not the state. All right, let's go part 12, the free exercise of religion. Sherbert versus Werner. A Seventh-day Adventist celebrates her Sabbath on the Saturday. She applied for unemployment benefits. They said, nope, we won't give you benefits because you won't work on Saturday. The court holds that's unconstitutional because this law substantially burdens her free exercise of religion. But then we get to Employment Division versus Smith. You have a Native American who uses peyote. It's a hallucinogenic cactus. He's fired from his job, and he applies for unemployment benefits. He's denied. They said, look, you're using controlled substances. We can't give you these benefits. The court holds, that's fine. This is a neutral law. It's not targeting Native Americans. It simply is a general law that bans using controlled substances. Okay. Next case, Church of Lukumi Babalu versus the city of Hialeah, Florida. Some of you are laughing. This involves the Santeria faith. The Santeria faith does animal sacrifices. They are very bloody with chickens and heads and blood. There's a lot of stuff going on. The city of Hialeah basically banned these types of ritual slaughters. The court held you can't do that. You can't target a specific religion and their exercise. 94, Hobby Lobby. You probably know this one. The Affordable Care Act required certain employers to provide contraceptive coverage for their workers. The Supreme Court said, no, you can't do that. Corporations are protected by federal law, and this violates their freedom of conscience. All right, moving right along. Let's talk about the Ten Commandments for a minute. McCreary County versus ACLU. In this case, a religious group put up a display of the Ten Commandments in a courthouse. The Supreme Court said, no, you can't do that. That violates the Establishment Clause. It affects an establishment of religion. But then we have Texas, my home state, Van Orden v. Perry. You've had this huge 6-foot granite display of the Ten Commandments. It's been there for half a century. It's never bothered anyone. The court says that one can stay. So why is the little display in Kentucky no good and the huge display in Texas good? I don't know, ask Justice Breyer. He was in the majority of both opinions. He seemed to say that, well, if it's been there for a while, it's not bothering anyone, let's leave it there, but let's get rid of the new one. Okay, that's where we are. Part 14, almost done, right on schedule. 2008, D.C. versus Heller. This case recognized the Second Amendment protects an individual right to keep and bear arms, not tied to militia service. And in 2010, in McDonald v. Chicago, the court held that both the federal government and the state government are protected by the Second Amendment. States cannot ban the ownership of firearms. Last part, part 15, taking private property for public use. 1922, Penn Coal versus Mahon. In this case, the state said you cannot drill for coal under a person's house. People had rights to dig for coal. The court said that was an unconstitutional taking. If you want to ban coal mining, you have to pay the property owner for it. Imagine that decision today, right? And the last one, a case that also hopes to overturn sometime soon, Kelo versus City of New London, 2005. The court held that if the government wants to take your property, they can, so long as it reaches a higher tax value. So if they want to take your house and make it into a Hotel 6, they can do that. If they want to take your house and make it into a 7-Eleven, they can do that. This case should be ripped away. And I'm done. 59 minutes on schedule. Thank you so much. Thank you. Thank you.
As long as you're willing to stay and ask
Oh,
questions.
please. I welcome questions. I have to rip through that Q&A, but I'd be happy to take questions. Yes, right there, sir.
Justice Roberts said that the public share was taxed. My understanding is that all tax bills have to be made in the House. And the farmer couldn't be sent. Is anybody arguing that?
Yes, so the question, if you can hear it, was that the Constitution requires tax bills to start in the House, not the Senate. And he asked, wasn't the Obamacare law originated in the Senate? Well, you mentioned a fake number bill. What was that phrase used earlier?
Dummy bill.
A dummy bill. We have something called a shell bill in federal law. A shell bill, which is basically a bill that's never meant to be passed. So the ACA actually started off with a House shell bill that had to do with Veterans Affairs. It had nothing to do with Obamacare. And they took the House bill and they sent it to the Senate and sent it back to the House. So technically it originated in the House, but there was a litigation saying that the shell bill business is garbage, right? This is not a real way to run a government, and the courts turned it away. Okay. Yes, right over there, sir. Yeah, what a good question. Yeah. So the question was whether the case involving, I think, Guantanamo Bay you're asking about, involving detention of alleged terrorists, might invoke the Korematsu decision. The short answer is no. The Bush administration made a very conscious choice not to cite the Japanese decision. They could have, but they didn't. Most people simply think those are really bad cases you shouldn't rely on. And in fact, in Trump against Hawaii, which involved the travel ban, the Supreme Court said that Korematsu is no longer good law. It kind of ruled it, but not really. So there was never any effort to rely on the Japanese cases. Yeah, in the back.
Yeah, I guess about 1.5 Indian law.
It was.
And you had Seminole. And I'm just curious, the Seminole leads to Florida was talking about mediating regulatory action. I remember in common law, when you read the Commerce Clause, the Commerce has the power to regulate commerce between states, and that's what people don't just stop there. I was always curious, in your classes, and in most common law classes, they never seem to continue to read all of the Commerce Clause says, and among the Indian tribes.
I read it.
And you always, because it always seems
I read it.
that if you look at what is limited in terms of Commerce Clause and what, the Congress can do, and where the restrictions are in the Commerce Clause side of things, the federal government gets away with a massive amount of tyranny and invasive overregulation on the tribal side, and yet it's the same clause in the Constitution. I'm just curious. I've always been interested in how common law professors sort of look at those two things because it's the same clause, and yet you have diametrically opposite limitations on federal power.
Yeah, I'll be honest. I mentioned the Indian Commerce Clause. I don't focus too much time on it, but it is an important part of our constitutional order. Justice Thomas has had another opinions recently about Indian law and the Indian Commerce Clause that says maybe we should look at it differently than the other Commerce Clause. So I don't know much, but I do appreciate the question. Other questions? Yes, sir.
So, I like to take the board of my
Don't we all?
but
Yeah.
I'm concerned about taking the board
Well, the question was about executive orders. Executive orders can take different forms. Sometimes they're orders, sometimes they're memorandums. They take a lot of different ways. But the idea is, I'm the president, I have my subordinates, we have our power, we don't need anything else from Congress, we're going to do it on our own. There's nothing wrong with an executive order in the abstract. If the president's actually doing what he has power to do, there's no problem. The question is, does he have the power to issue this order or issue this memorandum? And I don't like presidents doing things they're not allowed to do. All presidents do it, especially when Congress is gridlocked and doesn't get stuff done. So I think we'll see more of it, and the courts may intervene more, but I'm not seeing this trend decline. Yes, right there.
In your field of technology, are any interesting cases about the section of our rights versus technology companies?
Oh, sure. I gave a lecture this afternoon to the law students about 3D printed guns, which is something I'm litigating, and this is an issue that's going in the courts now, whether the First Amendment protects the right to share the files used to 3D print guns. So that's one case I've done a lot of work on, but thank you for the question.
All right, sorry, we're going to have to cut it off there.
You can come up and ask more questions. I'll be here for a while.
Apparently, according to Emil, we need to be out of here by 7:30. So first and foremost, the trash cans are out in the hallways.
Not my rule.
Yeah, apparently 7:30 is a late night party for the law school there. So if Josh can
visit with you outside.
Oh, I got to leave the room. Okay,
Great.
got it.
And he is the only person who's written a book that I know of who hasn't brought every copy ever written up.
It's on Amazon. Go buy a copy and order on Amazon. I'd be
I
happy
would
to.
encourage you to do so, and it's a unique book because he actually recorded various informational snippets that are unlocked by buying the book. You can go online and look at video and news reports and stuff from those cases. So thank you, Josh. Round of applause.
Thank you.